I would first like to thank members of the media for accepting this invitation to cover this virtual media conference. I would like to say good afternoon to all those who are listening to this media conference, which is being carried live on Power 1021 FM and I-95.5 FM. Good day also to all who will be listening to the replay of the recording of this media conference, which will be replayed tomorrow at 9 a.m. on Power 102.1 FM and on Akashvani 106.5 FM and Sangeet 106.1 FM. As you know, I represented A&V Oil and Gas Limited in the dispute between A&V and Petrotrin. That dispute was by agreement of both A&V and Petrotrin, decided by 3 judges sitting as arbitrators. Both Petrotrin and A&V chose agreed upon the arbitrators. The other members of the legal team who appeared for A&V comprised Queen's Counsel Mr. Peter Knox of the United Kingdom, Mr. Ronnie Bissessa, Mr. Robert Strang of the United Kingdom, Mr. John Almeida of the United Kingdom, and Mr. Varun Gopal Gosain of the Forum of Lawgivers. Mr. Bissessa and Mr. Gosain are with me in this room in having this media conference. I am speaking at this media conference in my capacity as an attorney at law and one who served as a member of parliament and as the Attorney General of Trinidad and Tobago. I am speaking as one who had to marshal the facts of this case, which was presented by A&V, and who also had to study the defense which Petrotrin put forward to the arbitrators as a defense to the claim of A&V. I consider that I have a duty as a lawyer who was engaged in this arbitration between A&V and Petrotrin to inform the public of the truth, where the truth is being misrepresented to the public in statements which are being fed to the public. The reason for calling this media conference is because of those public statements which have been made since the judgment and continue to be made by the leader of the opposition and other members of the opposition party, which statements are not true. Those statements are not supported by the evidence accepted by the judges in the arbitration. I decided to explain all the relevant issues in this matter to members of the public so that the members of the public would decide whether what they are hearing from others, especially those in the opposition who seem bent to make false allegations in this matter, whether those statements are true or not. An essential component of the rule of law is for disputes to be determined by rules and procedures established by an adjudication process which is permitted by law. This is exactly what happened in the arbitration. The statements which are being made by the leader of the opposition are that A&V overstated the volumes of oil which it sold to Petrotrin, and that A&V received payments from Petrotrin for fake supplies of oil. Those allegations and statements were held by the 3 judges who sat as arbitrators to be untrue, and that they are not supported by evidence adduced before the arbitrators. The termination of the contract which A&V had with Petrotrin for it to supply oil to Petrotrin had its origin in the allegations made by the leader of the opposition at a public political meeting on the 10th of September 2017. She stated that she was reading from an internal audit report of Petrotrin, which showed that A&V was paid for fake supplies of oil sold by it to Petrotrin. She then alleged that A&V was getting away with that fraud and misconduct because A&V was a financier of the PNM and its chief executive officer, Mr. Hanik Bach, was a personal friend of the Prime Minister. She therefore linked the Prime Minister to the allegation made against A&V. The Prime Minister, however, from the records I have checked, official records, is not a shareholder of A&V, is not a director, and has no connection to A&V. The internal audit report, which she read from, however, was a draft report. It was not a final report. It was an interim report, a private and confidential report, which should not have got into the possession of anyone outside of Petrotrin. It did not contain conclusive findings. The leader of the opposition knew that it was not a final report. She knew that the report still had to be investigated in order to determine whether the contents were true. The leader of the opposition, however, from 2017 to 2021, continued to make these false allegations. The accuracy of the contents of that internal audit report were, however, disputed by the supplemental internal audit report, which was prepared by the same audit department of Petrotrin, and which was submitted to Petrotrin subsequent to the submission to Petrotrin of the internal audit report on which the leader of the opposition relied. The supplemental internal audit report challenged the findings of the internal audit report and undermined the credibility of the internal audit report. This supplemental internal report, however, was not disclosed to the public or to A&V by Petrotrin before the contract between A&V was terminated by Petrotrin. And when I say Petrotrin, I mean the Espini-led board of Petrotrin. The leader of the opposition on the 10th of September 2017, as I said, repeated these allegations. And during the general elections of campaign of 2020, the leader of the opposition made these false allegations as one of the lead issues in her political campaign speeches. The three judges in the arbitration, which decided the dispute in June 2021, held that A&V did not overstate the volumes of oil it supplied to Petrotrin. The three judges ordered Petrotrin to pay for the oil which A&V supplied to it, and decided that Petrotrin wrongfully used these false allegations against A&V to terminate the contract. The arbitrators awarded judgment in favor of A&V. The arbitrators ordered Petrotrin to pay to A&V damages for breach of contract. Since the judgment was delivered in June 2021, both A&V and Petrotrin entered into without prejudice discussions to explore efforts to amicably resolve the matter. Both Petrotrin and A&V entered into a settlement agreement. 2 days ago, on Sunday, the 26th of September 2021, Mr. Wilfred Espini, the then chairman of Petrotrin's board of directors, which terminated A&V's contract, took out full-page ads in all three Sunday newspapers to give his side of the story. In the first paragraph, he referred to the leader of the opposition's public statements, which prompted the termination of the contract. Mr. Espini, who led the board at that time, is now saying that Petrotrin relied on experts to terminate A&V's contract. Those very same experts, however, that Petrotrin relied upon stated in their reports that they relied on the data and information in the internal audit report and such other information provided by Petrotrin to give their opinions. They did not conduct any independent investigation into whether the information in the internal audit report was correct or not. I will say more about this matter later in the statement. First, let me tell you what an arbitration is. The laws of Trinidad and Tobago permit parties to a contract to agree for any dispute which exists between the parties to be determined by arbitrators of their choice. Both Petrotrin and A&V agreed that they would have arbitrators determine whether these allegations that A&V overstated the volumes of oil to Petrotrin and that A&V received monies from Petrotrin for oil it did not supply to Petrotrin were true or not. The Arbitration Act of Trinidad and Tobago, Chapter 501, provides that decisions of arbitrators made in accordance with the Act would have the force of law. Those decisions can be registered with the Supreme Court of Trinidad and Tobago and can be enforced as a judgment of the Supreme Court of Trinidad and Tobago. The Arbitration Act provides for due process of law to be complied with in the conduct of arbitrations. The arbitrators, after a pre-trial process, which lasted for almost 2 years, and a trial which lasted for 2 weeks, in which witnesses on behalf of A&V and witnesses on behalf of Petrotrin gave evidence and were cross-examined by opposing lawyers, decided that the allegations on which Petrotrin relied to terminate the contract were not true and were not proven. The Espinay-led board of Petrotrin therefore wrongfully terminated the contract. The 3 judges who sat as arbitrators were persons who were experienced judges and who served at the highest level of the judicial systems in the Caribbean and in England. It is important for the country to know the qualifications and track record of three judges. Petrotrin chose Justice of Appeal Stolmeyer as an arbitrator. A&V chose Lord David Hope as an arbitrator. And both A&V and Petrotrin agreed for Sir Dennis Byron to be an arbitrator and to be chairman of the panel of arbitrators. First, the Right Honorable Sir Dennis Byron is a fellow of the Chartered Institute of Arbitrators. He was the president of the Caribbean Court of Justice. The Caribbean Court of Justice is the final court of appeal for several Commonwealth Caribbean countries. He was also a permanent judge of the United Nations International Criminal Tribunal for Rwanda, and he later became the president of that tribunal. Lord David Hope was the vice president of the Supreme Court of the United Kingdom. He was also the vice president of the Judicial Committee of the Privy Council, which is the final court of appeal for Trinidad and Tobago and for several other Commonwealth countries. As a practicing barrister at law in Scotland, Lord Hope became Queen's Counsel in 1978. His practice of law included commercial law, contract law, construction, and oil and gas law. After his retirement from the United Kingdom Supreme Court and the Privy Council, he has been a judge in arbitration in countries throughout the world. Third, retired Justice of Appeal Humphrey Stolmeyer was a Justice of Appeal of the Court of Appeal of Trinidad and Tobago. Before becoming a judge, he had an extensive practice in corporate and commercial law in one of the leading firms of lawyers in Trinidad and Tobago, J.D. Saley and Company. He has a diploma in international arbitration from the Institute of Chartered Arbitrators. He's also a Justice of Appeal non-resident of the Turks and Caicos Islands, and he also sits on occasion as an acting Justice of Appeal of the Eastern Caribbean Supreme Court. He's also a member of the International Chamber of Commerce Court of Arbitration and a fellow of the Chartered Institute of Arbitrators. These are the 3 eminent judges who sat for 14 days, heard evidence, heard cross-examination, and for 2 years in a pre-trial process, decided that these allegations, which were being published all over the country by the leader of the opposition, and which seem to have been adopted by the Espinay-led board of Petrotrin, that they were false. Before the contract was terminated, A&V's lawyers were in communication with Mr. Wilfred Espinay, who was then chairman of the board of Petrotrin. A&V, through its lawyers, made representations to Petrotrin through Mr. Espinay that A&V would be willing to have a meeting with Petrotrin to answer any allegations so that Petrotrin can see for itself what evidence A&V has to show that Petrotrin is wrong in alleging that A&V did not supply the requisite volumes of oil. Mr. Espinay, in those letters written on behalf of A&V by its lawyers, took the position that the internal audit report was an interim report which had to be investigated, and that he preferred to conduct a proper review of that internal audit report before he had any meeting with A&V. All this is in writing, you know. All this was before the arbitrator. Mr. Espinay subsequently announced in the media that Petrotrin retained 2 companies, Kroll Consulting Canada Company and Gaffney Klein and Associates, to conduct a review of the internal audit report. Upon that publication in the media, A&V's attorneys at law again communicated with Mr. Espini for him to meet, for A&V to meet with Kroll and Klein to give responses to any matter they wished to hear A&V on. Mr. Espini took the position that that was not necessary. After Kroll and Klein submitted their reports to Petrotrin, he, Mr. Espini, and the board would then have a meeting with A&V. After it was published by Petrotrin in the media that Kroll and Klein submitted their reports to Petrotrin and that Petrotrin supports those reports because Kroll report and the Klein report supported the internal audit report, A&V through its lawyers wrote to Mr. Espini asking him, let us meet, let us show you, you tell us what you want to hear from us, we will give it to you, and we will convince you that there was no basis for these allegations. Do you know what Mr. Espini said? Mr. Espini took the position that, that these reports that he got were private and confidential, and he was not prepared to make it available to A&V. So Petrotrin's position was that it intended to rely on the contents of the internal audit report on which the leader of the opposition relied and on which Petrotrin relied. He was prepared to rely on the statements made by the leader of the opposition at a public political meeting, and he was prepared to rely on the contents of the Kroll and the Klein reports to determine whether he should terminate the contract with A&V. But he was not prepared to give to A&V copies of those reports in order for them to give their answers to Petrotrin, for Petrotrin to consider in the decision-making process for Petrotrin to decide whether to terminate the contract. In the paid newspaper advertisement made by Mr. Espini on Sunday, the 26th of 2021 of September, Mr. Espini publicly disagreed with the arbitration settlement made between A&V and Petrotrin, and he stated that Petrotrin terminated A&V's contract based on the findings made by Kroll and Klein reports. After Mr. Espini denied A&V the rules of natural justice, the principles of fairness, did not want them to see the report, he is saying that the present board of Petrotrin did not make the right decision. Mr. Espini said that Petrotrin engaged Kroll and Kaffner Klein, and both consultant firms confirmed the internal audit findings. What Mr. Espini did not publish in that newspaper release was that he did not say that both Kroll and Kaffner Klein, in making their findings, relied on the measurements and data provided by Petrotrin. At paragraphs 11 and 12 of the Kroll report, the report said it did not conduct independent testing of the flow meters or of the pump capacities or the storage capacities and sales tanks capacities, nor did Kroll examine the test results of the custody transfer tickets of the oil being sold from A&V to Petrotrin. The Kroll report also said it did not receive custody transfer tickets outside of the January to June 2017, and therefore relied on a Petrotrin prepared schedule for custody transfer ticket data outside of this period. In other words, my fellow citizens, what Kroll was saying is that it did not do any independent investigation of Petrotrin's data and information in that internal audit report. Kroll was saying that it reviewed the data and information which was on that internal audit report, and it gave an opinion on that data. My fellow citizens, it follows therefore that if that data and information in that internal audit report were inaccurate, then the opinion given by Kroll would also have been inaccurate. That is exactly what the three judges in the arbitration had to deal with. Having experts saying that they didn't do an investigation, they relied on data to give an opinion. Gaffney Klein too relied on Petrotrin's measurements and data. In its report on page 2, Gaffney Klein said it spent 3 days in Trinidad meeting with Petrotrin's representatives, but that Petrotrin provided well and subsurface information on the Catskill field, joint operations, the crude oil pipeline system, and the major tank farm. And at page 3, Gaffney Klein made it clear that it relied on data and information provided by Petrotrin, the limited scope of engagement, and the time permitted to conduct the evaluation. So Gaffney Klein was saying it did not independently verify the information. It is clear, therefore, that what Gaffney Klein was saying was that it did not independently verify the information in the internal audit report, and it merely gave an opinion based on that data and information. The cumulative effect of these admissions by Kroll and Gaffney Klein is that these two firms did not conduct any investigation into the data which was contained in the internal audit report and which was supplied by Petrotrin to them. It follows that if the data in the internal audit report or any information supplied by Petrotrin was inaccurate, the opinions given by these two firms would also have been inaccurate. In the course of the hearing before the arbitrators, A&V also made reference to the judges to an email sent by Gaffney Klein to one Ms. Khalis Narain Singh of Petrotrin on the 23rd of July 2019, in which Gaffney Klein, Petrotrin witness, complained that it was now receiving information from Petrotrin that was not disclosed in his visit in September 2017. And do you know what Gaffney Klein said in that email? Gaffney Klein told Petrotrin it will be difficult for Petrotrin to rebut some of AV's arguments. That's Petrotrin witnessing that. It is therefore wholly improper for Mr. Espinier to try to avoid responsibility for what he did at Petrotrin at the time by shifting the blame to Petrotrin's experts when these experts relied on Petrotrin's own faulty measurements and data which were contained in the internal audit report. And the supplemental internal report of Petrotrin prepared by Petrotrin Audit Department challenged the data on the internal report, audit report of Petrotrin, as I would show you shortly. In addition, the arbitrators in their judgment were critical of Petrotrin's response to A&V's request prior to the termination of A&V's contract, for A&V to be provided with these expert reports so that A&V could respond. Petrotrin had repeatedly told A&V that it would be given a chance to do so, but it was never given such a chance because Petrotrin then said that these expert reports were privileged and confidential. Yes, the Espini-led board said that. Mr. Espini promised a meeting, he did not give it, and he, in effect, denied A&V the opportunity to contradict the report. Let me read to you what at paragraph 43 of the judgment of the arbitrators, what these three judges unanimously held. It stated that Petrotrin was not willing to engage with A&V in a fair, even-handed, and open-minded discussion as to what the reasons were for the apparent discrepancies which had given rise to the decision of the international audit team to investigate what was happening at Catskill. While Mr. Espini was at pains to underscore that the Espini-led board was fair and transparent in terminating A&V's contract, the arbitrators said otherwise. This is what the arbitrators stated in their judgment. Petrotrin's single-minded and uncompromising approach left no room for discussion as to where the truth might lie, and its conduct fell so short of what the duty to act fairly required that the arbitrators have to conclude that its decision to terminate the contract was wrongful. Mr. Espinay, in his media release on Sunday, said he shared Petrotrin's former lawyer's extremely strong view that the arbitrator's decision should be appealed. I do not know whether Mr. Espinay read the judgment of the 3 judges, which is not yet in the public domain, but it does not seem prudent for him to unreservedly accept the extremely strong views of Petrotrin's former lawyers, which I do not know if he has seen those views, while rejecting the unanimous view of 3 eminent jurists who carefully reviewed the evidence. Moreover, Petrotrin's case presented at the arbitration was strongly rejected not only by 3 eminent jurists, but there were opinions given for Petrotrin by Mr. Simon Hughes QC and former judge of the Caribbean Court of Appeal, former judge of the Caribbean Court of Justice, Mr. Ralston Nelson, senior counsel, who from the publications advised not to appeal. It is for this and other reasons I have publicly stated that the judgment given by these 3 judges ought to be made available to the public and laid in the Parliament. The Guardian, in a recent editorial, has supported this call. Openness and transparency and accountability of the government to the public require the government to take steps to lay this judgment in the Parliament so that the members of the Parliament, the members of the media, the public can have access to the contents of this judgment. The public has the right to know the truth as decided by the arbitrators in this matter. That judgment would show what happened with A&V, what happened with Petrotrin, what happened at the hearing, what evidence was led. This would allow the public to judge the public comments which are being made by distinguished individuals, including Mr. Espinay and others. The 3 judges held that Petrotrin did not act fairly in its dealings with A&V in respect of the allegations which were made by Petrotrin against A&V as the basis for it terminating the contract, as I showed you from what I read shortly. The cumulative result for Petrotrin's conduct was that Petrotrin did not have possession of all the relevant information it should have had. It also did not make the necessary inquiries which it should have made before it decided to terminate the contract. That is what the arbitrator said. And if the Espinay-led board had given A&V the opportunity to bring forward its evidence to show what they were saying was not true, it may be we would not have been in this difficulty here today. The judges decided that based on the totality of the evidence which was before them, the inquiries conducted by Mr. Espinay and the Espinay-led board were inadequate. It did not meet the requirements of the law. It offended the rules of fairness and natural justice. Petrotrin acted only on the allegations made in the internal audit report, the Kroll and Klein reports, and probably the representations made by the leader of the opposition, but it did not consider any representations made by A&V in respect of the contents and conclusions of the Kroll and Klein report. And Petrotrin decided 7 days before it terminated the contract to send a lot of questions and give it 7 days to answer those questions. But it had 3 months period to give A&V the opportunity to bring forward its evidence, but it refused. The arbitrators found that Petrotrin did not act fairly towards A&V before it terminated the contract. They found that Petrotrin did not give A&V sufficient opportunity to respond to the allegation, and also did not give to A&V copies of the Kroll and Klein report. The arbitrators found that Petrotrin did not satisfy the arbitrators that its decision to terminate the contract with A&V was objectively reasonable in the circumstances. Those were the words of the arbitrators at paragraph 43 of the judgment. The supplemental internal audit report. If I have time, I would read to you what the arbitrators stated at paragraph 43. But let me go to the supplemental internal audit report. Mr. Espini and the Espini-led board acted on the contents of the internal audit report and the allegations made by the leader of the opposition, and took steps which led Petrotrin to terminate the contract it had with A&V. Mr. Espini, however, never disclosed to the public or to A&V the contents of the supplemental internal audit report, which, as I stated, challenged and undermined the data and information contained in the internal audit report. The supplemental internal audit report was prepared by the same internal audit department of Petrotrin, and that supplemental audit report was submitted to Petrotrin a few days after the internal audit report was submitted to it. At no stage during the correspondence between A&V's attorneys at law and Mr. Espini before the contract was terminated did Mr. Espini disclose to A&V or to the public the contents of the supplemental internal audit report. The supplemental internal audit report, which was before the arbitrators, showed that the findings in the internal audit report were likely to be unreliable, having regard to the deficiencies in the data and information which it contained. The supplemental audit report identified those deficiencies in the data. The internal audit department of Petrotrin, in the supplemental internal audit report, therefore challenged the data contained in the internal audit report on which Petrotrin relied and on which the leader of the opposition relied. Those allegations in the internal audit report was the basis of the allegations on which the leader of the opposition made these serious allegations against A&V, against its chief executive officer, Mr. Baksh, and the unfounded allegations against the Prime Minister of Trinidad and Tobago, Dr. Rowley. The supplemental internal audit report concluded that Petrotrin's measurement system and its measurement procedures for the purchase of crude oil from independent operators were wholly inaccurate and unreliable. Let me tell you what were the findings of the arbitrators. These three eminent judges decided the following. A&V was not guilty of any wrongdoing which Petrotrin alleged against it. Next one, the volume of crude oil which A&V alleged it supplied to Petrotrin were not overstated or falsified in any way. Next one, there was no factual basis for alleging that A&V did not supply the volumes of oil it alleged it supplied to Petrotrin. A&V was not guilty of any wrongdoing in the process for the supply of crude oil to Petrotrin, and therefore Petrotrin was not entitled to treat any crude oil which A&V delivered to Petrotrin as not having been delivered. In other words, these three judges decided that A&V's supplies of crude oil to Petrotrin were not fake supplies of oil. And the judges therefore decided that since they were not fake supplies of oil, Petrotrin had to treat any crude oil which was delivered to Petrotrin during the period by A&V. They had to treat the oil as being delivered and they must pay for it. This was not a case of fake supplies of oil. This was a case of fake allegations against A&V and the Prime Minister of Trinidad and Tobago. The arbitrators decided that Petrotrin wrongfully terminated the contract it had with A&V for the supply of crude oil, and it ordered Petrotrin to return two sums of monies which Petrotrin held in an escrow account because it took the position that A&V was supplying fake oil. The arbitrators ordered Petrotrin to return those sums of monies to A&V. Those sums of monies were 84,699,879.47. And then there was another amount, US 2,284,398.40. A lot of money Petrotrin was holding on the basis that there was fake oil. And then Petrotrin ordered damages and compensation to be assessed But as you know, in the settlement agreement, what the A&V said, that it decided to go back in the field, work the field, and don't worry too much about monetary compensation. Let me tell you about the pre-trial process. There was a pre-trial process before the trial took place in December last year. In the pre-trial process, both Petrotrin and A&V were given every opportunity to produce whatever evidence they wished to call at the trial. A&V filed a claim and a statement of case. Petrotrin filed a defense and a counterclaim. Then A&V filed a reply. These documents are considered to be pleadings, and what they do, they give a signal to the other side what is the nature of the case the claimant has, and what is the nature of the case Petrotrin has, and what sort of evidence they would be adducing at the trial. The pre-trial process consisted of witness statements had to be filed. These are the witness statements of the witnesses who would be called at the trial. Those witness statements were considered to be evidence or note. When the witness goes in the box and say that they give this witness statement, they sign it, and the contents of the witness statement are true and correct. At the trial, this is not a fake trial, you know. This is a real trial. At the trial, you have Petrotrin lawyers, you have A&V lawyers, you have the arbitrators, just like a court. And what you have the witnesses in a witness box. And the witnesses give their name and they give, say, the statement, they give a true and correct, they sworn that statement. And then Petrotrin lawyers could have cross-examined all of the witnesses that A&V called. Among the witnesses who gave evidence for A&V was Mr. Hanif Baksh. He went in the witness box. He was cross-examined by Petrotrin lawyers. In his evidence, he showed that A&V produced the volumes of crude oil it supplied to Petrotrin. He was cross-examined on that issue, and he gave the answers to support his evidence. Petrotrin, through its lawyers, could have put anything to Mr. Baksh that they were alleging. And they put, and he answered. He didn't hide from the witness box. He went in the witness box and he faced the music. Another witness for A&V was a world-recognized expert, Mr. David Aaron, who studied the Catskill field as part of the Trinidad and Tobago geology. He is a man of high repute. He went in the witness box and he showed from documentary evidence, from the study he did, he demonstrated with charts, he gave evidence that the Catskill field had the reservoir capacity of crude oil for A&V to have produced the quantity and the volumes of oil it produced. He was cross-examined. With the greatest respect, Kroll and Klein were in no class to that evidence because they merely gave evidence of an opinion on data. Mr. Aaron gave evidence to show that he knows the field. He knows what it is to test to see whether the field has the capacity to produce the oil. He produced diagrams, real diagrams of this area and the geology of the area. Lord Hope, do you know who Lord Hope was? Let me tell you who Lord Hope was. Lord Hope was in the Privy Council in the House of Lords. He is one of the leading judges in the world on commercial law. His judgments are in all the law reports of the Commonwealth. His judgments are followed by judges throughout the world. He has given leading judgments in commercial law. The judges have to refer to his judgments. Sir Dennis Byron, a man of great repute, respected throughout the Commonwealth, head of the Caribbean Court of Justice. So with the greatest respect to some of these fellas who coming out and saying nonsense, that is why I want the public of Trinidad and Tobago, I want members of the media, I want members of Parliament, I want everyone to read this judgment. And I am calling on the Prime Minister of Trinidad and Tobago, the Cabinet of Trinidad and Tobago, that they have a duty to put this document in the Parliament for the public to read. So you had A&V call witnesses, Petrotrin call witnesses, and this great Kroll and Klein, they went in the witness box, they were cross-examined, they had every opportunity to answer every question. And I want to tell you something, I was so confident about this case that one of my junior lawyers, Mr. Robert Strang, cross-examined Klein. But another matter which I want the public to read, I want the public to see, I want the public to know. In the evidence before this tribunal, there were documentary evidence from Petrotrin, from the joint venture department, contemporaneous record of the production of oil in the different fields from contractors. And in the documentary records of Petrotrin from the joint venture department, they showed that the oil which A&V produced, it supported his evidence that he produced the volumes of oil that Petrotrin was denying it produced. So we had evidence from Petrotrin, documentary evidence, not from a witness who just come and give the evidence. Yes, a person who was working in the joint venture department came also to testify and to give evidence of those records, and those records were in evidence already. And he supported A&V's case. He criticized Mr. Bach, but he supported A&V's case in respect of the production of oil. A&V called 13 witnesses and Petrotrin called 8 witnesses, and they were all cross-examined. This is what the arbitrators found at paragraph 73 of their judgment. We are satisfied, and I'm quoting, we are satisfied that the Catskill field was capable of producing the quantities of oil that the claimants say they sold to the respondent. That is because the information that is before us shows that this was so. This information also reveals significant defects in the audit report on which the respondent, that is Petrotrin, relied when deciding to terminate the contract, which they would have discovered had all necessary inquiries have been made. Even the Gaffney Klein report was criticized by the arbitrators. At paragraph 54, the arbitrators said, based on the Gaffney Klein's evidence, the measurement system of oil supplied on which Petrotrin relied to terminate the contract was at relevant times imperfect. Consequently, the variations between the measurements of crude oil pumped and the amount received were to be expected in the ordinary course of events. Those who are outside there, who are saying that this was an unfair trial, or it may have been an unfair trial, let me read to you what Petrotrin's senior counsel stated to the arbitrators when they concluded the hearing and they reserved to give judgment. I wanted to thank you, Sir Dennis Lord Hope, Justice Salmeyer, for presiding over these proceedings so smoothly over the past 3 weeks, and even before in the pre-hearing days. You were able to deal with anything that the parties threw at you calmly and efficiently, and your rulings were always prompt and, more importantly, fair. I think the parties, if I may say so, should be commended for their selection of this tribunal. We could not have asked for a more eminent, experienced, and mature panel. Petrotrin is talking here. This was truly an international arbitration. We had representation from Trinidad, St. Lucia, Scotland, the United States, and Canada. It was for us a model on how one can conduct complex litigation remotely in the 21st century. Through you, Sir Dennis, we would also like to thank the Secretariat, etc., and that is about the Secretariat. And we want to wish Merry Christmas, etc. Queen's Counsel, Mr. Peter Knox, was short. He responded by saying he was grateful to the tribunal and was happy to echo the comments made by senior counsel for Petrotrin. He supported what she said. A&V in its media release on the 23rd of September stated that it was advised by its lawyers that it was prepared for any challenge to the decision of the arbitrators. Its lawyers advised that A&V was entitled to damages in the sum of $800 billion. A&V, however, took into consideration that an appeal process could have taken a few years, and that in the meantime, it was better for A&V to go back into the cattle field in order to earn money, but also to produce oil for the country, which would assist the national economy. It was in that context A&V did not pursue the judgment in its favor for damages to be assessed and accepted a reduced sum of $18 million of damages. I should tell you that A&V has a claim against the leader of the opposition for damages for libel. A&V and its chief executive officer, Mr. Hanish Bak, has pending in the High Court a claim for damages against the leader of the opposition for defamatory statements made by the leader of the opposition from the 10th of September 2017 to the present date. A&V and Mr. Baksh are claiming aggravated and exemplary damages against the leader of the opposition for publishing these false allegations. Subsequent to the decision of the arbitrators in June 2021, the leader of the opposition has continued to publish these false allegations, which are defamatory of both A&V and Mr. Baksh. The leader of the opposition has been given notice that in respect of every defamatory publication she has made against A&V and Mr. Baksh over the last 4 years, that the court would be asked to look at each of these publications and award extra damages on the basis of aggravated and exemplary damages. The basis is that the leader of the opposition knows that the statements are defamatory, but she continues to make them. The defenses put forward by the leader of the opposition are justification, where she cannot prove that these allegations are true. She pleaded qualified privilege, but that defense is destroyed if there is malice, and based on all the publications, there is strong evidence of malice by the leader of the opposition against A&V and Mr. Baksh. She also put forward a defense of fair comment. That defense is based on the facts on which she made a comment being true, so she cannot establish those defenses. We are looking forward to this trial because I think that a lesson must be taught to leaders that they have a duty to tell the country the truth. Before I give you my conclusion, I promised that I would want to read to you if I could find it, because I think Peter, well, I think I don't have it at least. In the meantime, oh yes, at paragraph 43 of the judgment, this is what the arbitrator said. When we look at the course of the respondent's conduct overall during this period, we are left in no doubt that the respondent was not willing to engage with the claimant in a fair, even-handed, and open-minded discussion as to what the reasons were for the apparent discrepancies which had given rise to the decision of the internal audit team to investigate what is happening at Catskill. Its single-minded and uncompromising approach left no room for discussion where the truth might lie. As the claimant says, it had plainly prejudged the issue. Whatever the reason, its conduct fell so far short of what the duty to act fairly required that we have to conclude that its decision to terminate the contract was wrongful. The result is that it was not in possession of all the information that it should have had, that all the necessary inquiries had not been made, and that the decision to terminate cannot be said to have been objectively reasonable. Now, my fellow citizens, in conclusion, I have served as an opposition member, and I have served as a government member. I have served as an opposition chief whip. I have served as a leader of government business. And I have served as an attorney general and sometimes as Minister of Legal Affairs of Trinidad and Tobago. And this matter is close to my heart because I know parliamentarians' duties are adversarial in the parliament. In the opposition, we would criticize the government. The government would criticize the opposition. But there was one thing during my time, I do not know if it has changed, but we are not perfect. We were not perfect. We make mistakes. We would sometimes say inaccurate things. But as far as I know, when it is recognized that these statements are decided by a court of law or by a tribunal which is authorized by law, or there are no facts to support something, you do not keep on making it. That is irresponsible. That is not discharging your duty to the public. I am no longer in politics, and I do not intend to get back into politics. If I decide to get back into politics, I think you must tell me I have gone out of my mind. I am no longer in politics. But I want to tell the people of Trinidad and Tobago that there are certain qualities that the people must look for in order to determine whether it is truthful or it is untruthful what they are saying. And I want to just share some thoughts with you, the public of Trinidad and Tobago. The conduct of the leader of the opposition and some opposition members in making these false allegations against A&V and the Prime Minister brings into focus the duty of parliamentarians and persons in public life. The conduct of these parliamentarians in making these defamatory allegations, in spite of the findings of the 3 judges who sat as arbitrators, brings into focus whether these members of the opposition are interested in giving to the public the truth or are interested instead to spread untruths. The judges found that A&V did supply the requisite volumes of oil to Petrotrin, and that A&V did not overstate the volumes of oil supplied to Petrotrin. The judges ordered Petrotrin to pay to A&V the monies it was holding for A&V, which Petrotrin withheld from A&V, because Petrotrin relied on the allegations in the internal audit report that A&V made fake supplies of oil to Petrotrin. The leader of the opposition and some members of the parliament are fully aware that the allegations which they were making, and at least now which they are making, are false, but they have continued to make them because, in my view, they see it as scoring political points against the government. Yes, you can score political points, but score political points based on truth. Parliamentarians and persons in public life are required to act at all times selflessly, which means that they are required to be truthful in the performance of their roles and duties. They must act as leaders in the country to actively promote the principles of truth in whatever they do. Political leaders and parliamentarians must set examples to the members of the public in speaking the truth, because their behavior and their utterances would be adopted by our students who are in the primary and secondary schools, and they are the future leaders of our country. The requirement for parliamentarian persons in public life to at all times act selflessly means that there is an obligation imposed on them to act solely in the public interest. In the document titled The Recommended Benchmarks for Codes of Conduct, which applies to members of parliament and which was published by the Commonwealth Parliamentary Association, and the Code of Ethical Political Conduct, issued by the Council responsible for political behavior, signed by both the PNM and the UNC. Parliamentarians are required to act selflessly and to be truthful. Parliamentarians and those in public life would not be acting in the public interest if they are untruthful. Parliamentarians and those in public life do not act in the public interest when they know that allegations which they are making are false, but continue to make them, knowing full well that they are defaming parliamentarians or a fellow parliamentarian to satisfy their own personal or political agenda. Their paramount interest then becomes not the public interest, but their personal and political interest in publishing false allegations against a fellow parliamentarian or fellow parliamentarians. Political integrity is not defined only by the requirement for politicians not to be financially corrupt. Political integrity also requires politicians to adhere to moral values, for them to speak the truth to the public, and for them not to deliberately spread false allegations against fellow members of parliament in order to score political points or to obtain political support from the members of their political party or from members of the public. Politicians do not only betray the public trust when they enrich themselves from the wealth of the state, thereby corrupting the politics for private gain. Politicians also betray the public trust when they purposefully mislead the public by speaking untruths on matters of great public importance in order to promote their personal or political agenda. This undermines the democratic process. The paramount duty is to put the public interest first. Politicians are required to be in politics to serve the people and not merely to serve themselves by putting their political or personal agenda before the national interest. Thank you very much, and I would invite any questions that the media want to ask.
Mr. Maharaj, I'm not sure if you're hearing me. This is
I'm hearing you.
This is Curtis Williams from Guardian Media. Trying to find out something. Would you say in law, inability to prove a case is the same as there being no case?
Well, according to our law, there are certain essential ingredients for you to establish a case. And the law does not act in certain circumstances on allegations. Act that if you are saying that you are entitled to terminate a contract, you must prove misconduct. And if you cannot prove misconduct, you're not entitled in law to terminate the contract. So, and also the law required that before you terminate a contract under this contract, before you terminate a contract, you have to act fairly. So I would say that in this case, really and truly, there was no question based on the findings of the arbitrators basically found that Petrotrin didn't even reach near to the threshold.
Well, I ask you that because I do have a copy of the judgment, which you are trying to made available. And the judgment does say that what happened, that the findings at least is that the arbiters felt that Petrotrin did not prove its case. Nowhere in the judgment says that there was no case.
Well, that is exactly what I'm telling you. If you go into court, it's for the arbitrators to decide if you establish your case. So if you have not proved you're justified in terminating the contract, you have not proven your case. Petrotrin's case on paper was that they were entitled to terminate the contract. But that is why the arbitrator said they have not proven the case and they are not entitled to terminate the contract.
And I'm not going to keep you long. I just want to ask two very quick questions. The second one, why do you think AV Oil and Limited, why do you think they would have been singled out, if you think they were, by Petrotrin? That's the one question. And the second question, how do you explain from the time of July, and I've looked at not just Petrotrin's records, but the Ministry of Energy records as well. How do you explain, since between July and December 1, when the contract was terminated, the significant fall off in production at the Catsell field? July 11th, being the date that the internal auditors visited Catsell. How do you determine that almost 80% fall in the production during that period?
Mr. Williams, that was part of Petrotrin's case, and the arbitrators consider that. And you had a situation where while Mr. Baksh was on the field, there was an aggressive drilling program. When he was thrown out of the field, there was not such an aggressive drilling program. And one of the things which the evidence showed is that with the aggressive drilling program, with the cluster wells drilling on the field, that was totally different to other kind of drilling. And that could have accounted for the excess production of oil. But if you read the judgment clearly and you understand the evidence of Mr. Aaron showed that you can have high, and then you could have low dips, and then you could have high again. And I want to tell you, one of the reasons that Mr. Baksh wanted to go back in the field. Mr. Bakch is confident that that field, based on the evidence that he has, expert evidence that he has, that field has large reservoirs of oil, but a contractor will have to invest a lot of money into the field to have aggressive drilling program, and it can produce a lot of oil.
Thank you.
But the arbitrators went into all of that when you read the judgment. And that is why you have a court of law. We have not reached a stage yet in this country where a court where people have all the opportunity of producing the evidence. You have eminent judges deciding the issue, but then we could have another court outside and saying, well, it could have been suspicion, it could have been this. People are entitled to express their opinion, but I think an essential part of the rule of law is that we accept the decision of the courts. We can criticize it, we accept the decision of the courts, and we accept the decision of arbitrators authorized by law when the parties had every opportunity to put their case. This is not a case where the judge did it ex parte and you did not have people where both sides had every chance to adduce whatever evidence, make whatever submission.
Mr.
Any other
Maharaj,
questions? Yes, please.
Alicia Boucher from TV6 here. I was wondering, was it ever found or found out as to what may have caused the discrepancies with the first internal report and the supplemental report, seeing that they were done by the same internal auditors within Petrotrin? Did that ever come out as to why there was that difference between that first report and the supplemental report?
Well, one of the things that came out both from the expert evidence and from the evidence on the ground is that the system of the measurement of oil is very primitive. And as the arbitrators found, with that system, you can have variations from time to time. So in this case, even you had evidence where the question even arose at one time whether the condensate from LNG could have affected whatever assessment was made. So I think what happened is that A&V filed its case and was saying that you could not terminate the contract based on these allegations which you were making. If you had to establish these allegations, you must show that we did not produce the oil. We had evidence to show we produced the oil. Then Petrotrin said, well, we could not pump the oil. We brought a pump expert, and the kind of pump that we had, the make of the pump, it showed that we pumped the oil, and the arbitrators accepted that. So if it is that we showed that we could have produced the oil and we could have pumped the oil, if Petrotrin's system of measurement is primitive and could have errors or slight variations, we are not responsible for that. We had record, which is supported by the joint venture department of Petrotrin, that we produced the oil and we pumped the oil. So I think that was sufficient for us.
Okay, and I also wanted to find out, when is the next hearing in terms of the High Court case with for defamation, and what is supposed to happen at that hearing? Yeah,
Mr. Bissessa, who is the instructing attorney, junior counsel in that matter, no, he's the junior counsel, Mr. Baron Gopal, the instructing attorney. He told me that later in the year there'll be a pre-trial review, but there's no fixed date of hearing. But I think it's a case that you all should come and witness, because the leader of the opposition would have to give evidence, and she'd have to prove what she said was true. And she would have to prove that this was a fair comment and come within qualified privilege. So I think it's of public interest. I promise I'll let you all know when the case is.
Okay, thank you. And how confident are you going into this case given the recent ruling?
Which case? The libel case? Well,
yes.
I'll reserve but you could see that confidence on my face, but I'll reserve that statement for later. I don't want to take it away from this issue. You could rest assured. You could rest assured that Mr. Bissessa would not have filed that case unless he had 100% confidence that he would have won that case.
And this case was filed when?
That case was filed in 2017. a few
Okay.
days, a few days after the 10th of September 2017, when these allegations were made.
And if I may ask, how has this case for libel, which seems to be, if you want to put it, how has this case taken this long when compared to the more substantive case which has now been concluded?
But there are two different kind of cases. The case against the leader of the opposition is a case in the high court system. The arbitration case is a case which was done by arbitration, which is a quicker process. In other words, the parties had the control and the arbitrators had the control of the expedition of the process.
Thank you. Understood.
Any other question?
Yeah, Mr. Maharaj, if I could just follow up on Ms. Boucher's.
Is that Mr. Williams?
It is.
Anytime, Mr. Williams. Anytime, Mr. Williams.
If I could just follow up on her question about the faulty equipment used in the measurement. If we are to follow your argument, can't we also say that the faulty equipment was used in the second internal audit, and therefore we are not even sure which one might be correct, whether the first or the second, if we are using the same faulty equipment?
Mr. Williams, what you're forgetting is I don't have that onus of proving it. Petrotrin has to say whether its equipment is good or faulty and etc. My duty, or the duty of my client, is if Petrotrin says it terminated a contract because A&V was supplying oil and the Prime Minister was protecting A&V, it is Petrotrin to show by evidence that that was the case. It was Petrotrin to show in this case that A&V could not have produced the oil it said that it produced. And Petrotrin had every opportunity to prove this. Even the arbitrators, Mr. Williams, said it. So now Petrotrin cannot act for an act of mercy. They had every opportunity to prove this. They called two international experts to, according to Mr. Espini, to review the audit report. So I don't have to give explanations, and it's not my job to give explanations for those things. The fact of the matter is, the simple issue in this case is, did Petrotrin prove what the leader of the opposition and what Mr. Espini said happened in this case? Did they prove that Petrotrin was supply, A&V overstated its supply of oil to Petrotrin? And the arbitrators, after looking at all the evidence, found that is untrue, that Petrotrin, and I read the finding to you, Petrotrin supplied the oil. I'm sorry, A&V supplied the oil. A&V did not overstate the volume of oil it supplied.
So can we, you said that Mr. Baksh is confident that he returns to the field and that there are huge reservoirs and so on in that field. If, and I give you a number, for example, A&V was claiming 5,000 barrels of oil per day and so on during the point in time in which Petrotrin raised concerns, right? If we go back into that field and that field is producing the 1,300 barrels of oil or 1,500 or 2,000 barrels of oil, do you then, what are we to make of it then?
But I think you're approaching this thing very wrong, because you're leaving out about aggressive drilling. You're leaving out what were the movement of the fields at the time. You're leaving out all of the expert evidence as to how these fields react. And better people than you, Mr. Williams, experts, were able to look at this, and they brought the evidence before the tribunal. And what it was found, that the field had the capacity to produce the oil, but in order to produce oil, money has to be invested, and there has to be a certain drilling programs and etc. So if a field is producing a lot of oil, and for some reason there is no money or nobody doing aggressive drilling on the field, there will be a different performance of the oil wells.
Yeah, I'm just asking if into the future, if we don't get back to those halcyon days and great numbers, whether there's any conclusion one may draw.
Well, you're asking me a very hypothetical question. And I think that what you should do is that you should wait until he goes back into the field. And if you have any questions to ask then, well, then I'll be prepared to answer. But I think that what you are asking, with the greatest respect, Mr. Williams, all of this was assessed and evaluated by the arbitrators, judges who have experience in judging these things. And they have made findings, and I'd prefer to rely on their findings than anybody who is making a statement outside.
Hi, Mr. Maharaj. If I may, Kijan Haynes here, News at 7. A follow-up to Curtis's question, though. Was there any recommendation, or were there any recommendations made to Petrotrin to ensure that this does not happen again? Because as it was raised, there were clearly discrepancies in the report, and the report may not be 100% accurate. What were they told to ensure that this does not happen again, especially seeing as for the next 10 years, A&V has a contract with, well, maybe not Petrotrin, but what is now Heritage, I believe.
But I think that you all are missing an important point. Although there were discrepancies, evidence was adduced, and the tribunal adduced that evidence from the expert and from Petrotrin record that A&V produced the quantity of oil that it said it produced. In respect of the variations and deficiencies, the arbitrators did not, I don't think they made any recommendations on that, but that's a matter for Petrotrin. And Petrotrin could always improve its procedures and etc. But in this case, there was evidence, David Aaron evidence was accepted by the arbitrators. The other experts' evidence, as I told you all, the other experts' evidence did not purely review the data. They did not go into the field and look at the performance of the wells and everything else that Mr. Aaron did from all the charts. So that this is a case not based on the variations or the deficiencies. This is based on real evidence that A&V produced the oil, and there was a pump expert from America who showed that A&V pumped the oil.
And a follow-up, as you mentioned that, do you believe that the government who would have appointed these independent firms, who we are now finding out did not do due diligence, do you believe that there was some error on the part of the government in doing that? How should that have been handled in your opinion?
Well, I don't want to get into that because that's a matter for Petrotrin and my position in this matter is that the Espini-led Petrotrin board failed in its duty to my client. I must say that the present board of Petrotrin, I think that the present board of Petrotrin, I personally didn't want the matter to be settled. The client insisted for the matter to be settled because I think that I think Petrotrin would have had to pay a lot of money for damages. But the client, lawyers have to accept what the client said. But the Petrotrin board, if I may say so, the present board made a decision which has saved the taxpayers of Trinidad and Tobago at least $800 million. So I think I will leave it to the new board of Petrotrin, if that is a new board, to see about those things.
Mr. Maharaj, Alicia Boucher here again. I just want to get clarity on one thing. The two experts that Petrotrin hired, is it that they did not get the supplemental report to look at, or they had both reports and they chose to rely on the first internal audit as opposed to the supplemental report?
Well, I would assume they had the supplemental report because when the report was disclosed, well, I don't know how it was disclosed, but when I got a copy of the report, I called a press conference, and I'm on record as calling a press conference, and I made the report available. So I would assume that they would have looked at that report, but the supplemental audit report was before the arbitrators. But I want you to try and understand this. There were no experts from Petrotrin, hired by Petrotrin, to go into the field and to investigate and to get the data, to obtain the data, to obtain the information. The experts were given documents which they accepted. So whether they accepted the data in the internal audit report or the supplemental audit report, that is all that they did. They gave an opinion on the report and other opinions in respect of their expertise. So that what happened on behalf of the claimant, there was data which we produced, which we supported, and which the tribunal accepted. And opinions were based on that data. So I think what you have to examine is that if Petrotrin at the time had to terminate the contract, what it should have done, it should have listened to what A&V said. A&V would have produced all its evidence to Petrotrin. Petrotrin would have then considered it. Petrotrin would then have had to get advice, and then it would have had to make a decision to terminate. What happened, Petrotrin looked at an internal audit report. There were some figures and data there. The same department said that some of those figures are unreliable. In the meantime, A&V is asking Petrotrin, give us a chance to come and talk to your expert, produce whatever we want to do, tell us what you want, we will show you, because we are confident from our records, we're producing the oil and we're supplying the oil. That's not what Petrotrin did. Petrotrin basically relied on the internal audit report, relied on the Kroll and Klein report, and terminated the contract. It may be that they were under pressure from what was happening outside in the politics. And that is why it is important for politicians to talk the truth. In this matter, normally if you have a private document, an internal document, and you know it is not final document, as a parliamentarian, you really do not release it to the public, because that could be a totally wrong document. It could be totally inaccurate. So those are some of the wrong things that happened in the case. And remember, for 4 years, we have been fighting this battle. I have been reporting to the population, but I was confident from day one, when I saw what was Petrotrin's attitude to this case, that they would fall into error. And when we examined the expert evidence and we got into the case, we knew that there was only one result. And I'm telling you today that this country is very fortunate that my client decided to settle the case and did not want to fight any further because he wanted to produce the oil. Because the taxpayers of this country, when it came to the damages and the interest and the legal costs, would have been over $1 billion. Any further questions? Okay, well, may I thank you very much and thank the radio station for being with us. Thank you very much.